Welcome back to Law and Crime, everybody. Alex Murdaugh is locked up right now in a South Carolina prison. He's serving 2 life sentences for killing his wife and son. But the threat of future legal proceedings still hangs over him. During his trial, Murdaugh took the stand to testify in his own defense. And he admitted under oath that he lied about practically everything, hiding his financial misdeeds as well as his opioid addiction. And in a separate case, Murdaugh is facing 99 charges in 6 different counties for stealing almost $9 million from clients in his law firm. But what impact will his testimony have on the fraud and embezzlement charges? In South Carolina, there is a statute that says that the prosecutors cannot use his past testimony as proof of wrongdoing in the financial crimes cases. So we asked a South Carolina criminal defense attorney if it's even worth to take Murdaugh to trial again.
He's already serving 2 consecutive life sentences. I mean, this is politics from here on out. There's not a criminal justice reason to have any additional trials. There are political reasons. And so I can see in a high-profile case that the prosecution would not want to come in and just dismiss 99 financial crimes, but it has no practical impact on Mr. Murdaugh's life.
Meantime, the man convicted of conspiring with Alex Murdaugh to take money from his client's legal settlements wants a new trial. Russell Laffitte is the former CEO of Palmetto State Bank. He filed a motion in federal court saying that Murdaugh's testimony during the double murder trial proves his innocence because Murdaugh testified that he committed the embezzlement and fraud alone without bringing anyone else on in his schemes. Laffitte says, or believes, that information will result in an acquittal for him on retrial. In fact, his legal team also contends that there were improper influences on the jury. Laffitte was found guilty on 6 counts of wire and bank fraud. He's been free on bail awaiting sentencing in the federal case. And Laffitte still faces 21 counts of financial crimes in state court. So, Brian, what do you think of this statutory law about statements on the stand, and how is that going to affect Murdaugh's future cases?
So as someone who practices in New York, this blows my mind because at first I think, well, this is a statement against a party opponent. It is not hearsay because it's literally an in-court statement, and he's saying it under oath, so why not use it? But then again, as a defense attorney, I kind of say, I want a bit of that. I want my client to be able to testify, say whatever he wants and not have it used against him. It sounds like he's literally having his cake and eating it too, but you can use his statements for the purpose of impeachment. So if he does try to play this game again, he could get impeached by what he said at the first trial if he testifies at future trials.
So, Terry, is he a mastermind, though? Did he know about this statute before he took the stand?
Absolutely, and I guarantee you he's not getting on the stand in the financial crimes case. So I think from the very beginning, he said to himself, look, I am going to weigh going to jail for the murder of Paul and Maggie, or, you know, perhaps I can get off in the financial crimes. And I definitely think he knew about that statute because he was kind of vague when he testified in his case, in that murder case. But he did say, and he did admit to, you know, having lied to all of these individual clients. So now, even on appeal, he could still win on appeal. There's a chance of that. He could get out, and then he goes to the financial crimes case, doesn't get on the stand, and, you know, has the chance of perhaps winning. I don't think that's going to happen, but.
Well, he might be a terrible defendant, but everybody said he was a good lawyer. But let's actually go now to Salt Lake City, where a female soccer player at Westminster College has filed a Title IX lawsuit against the school and her soccer coach. According to court documents, the student alleges that female soccer players were forced to sit in what was called the hot seat on the team bus. The lawsuit claims that freshmen and transfer players were asked intrusive questions about their personal lives, including sexual experiences and preferences. The team's coach, Tony LeBlanc, reportedly played a lead role in the questioning. The plaintiff says that she filed a Title IX complaint with Westminster College in 2021 when she had to sit in the hot seat herself, but she says that the college wanted to handle it as a personnel matter. The lawsuit states that LeBlanc was put on a short administrative leave, but when he came back, he retaliated against the student by benching her. The lawsuit is seeking damages, with the amount to be determined at an upcoming trial. The parents of an 18-year-old student who died after a hazing event on the Louisiana State University campus was awarded more than $6 million by a jury. Maxwell Groover, from an Atlanta area suburb in Georgia, died after taking part in a Phi Delta Theta fraternity ritual. It involved taking multiple long chugs from a bottle of strong liquor. An autopsy found Groover had a blood alcohol content of 0.49%. That is 6 times the legal limit. The most recent settlement came from a case against one of the former fraternity members and his insurance company. Groover's parents have already gotten money from settlements with 17 other defendants in the civil suit, including LSU and the fraternity. Groover's parents say they plan to use the money to fund the Max Groover Foundation. This is an organization that wants to end hazing on college campuses. Jury members, they seem to be struggling on the case of 3 men accused of killing up-and-coming rap sensation XXX Tentacion down in Florida. Day 4 verdict watch wrapping up and still no decision. Now, XXX Tentacion's real name was Jose Onfroy. In 2018, he was shot to death and robbed while leaving a motorcycle dealership. Prosecutors presented a lengthy case, pointing the finger at Michael Boatwright as the trigger man, Trayvon Newsom as the second gunman, and Dedrick Williams as the ringleader and getaway driver. The star witness was another co-defendant, Robert Allen, who pleaded guilty to second-degree murder and robbery charges. He actually testified against his alleged accomplices. Only one defense team actually presented a case. Michael Boatwright's attorney. He questioned a Broward County sergeant and detective on the stand in the hopes of poking holes in the investigation. The jury's gone over Robert Allen's testimony, surveillance video, and thousands of text messages and social media posts. While the co-defendants' guilt or innocence may seem obvious to some, we asked trial attorney Afi Patterson what could be tripping up some of the jurors.
Newsom's attorney did a good job of saying, harping on the fact that there's no DNA. There's another person there who could be the trigger person. There are no fingerprints. There should be fingerprints. Where is that? So there are some points that were made, but I don't think they were all strong enough. I think the issue is the charge is first-degree murder. It's a very heavy charge, and it may be hard for jurors to say first-degree murder for everybody when everybody played a different role, and a prosecutor couldn't definitively put every defendant there.
All right, let's try to make sense of it. I'm joined right now by my co-host, defense attorney Brian Buckmeyer, former trial attorney Terry Austin. Terry, the jury had more questions today, but it was mostly about scheduling. Like, how long should the judge allow the jury to deliberate without providing some sort of instruction to them?
Technically, the judge has to allow them to deliberate, and they haven't said that they are in any sort of deadlock, so he's going to allow them to go ahead and think about that case. But I do think at some point he's going to have to give them some sort of direction. They've been asking all of these questions about transcripts, as you mentioned, about text messages. They want to hear almost all of the evidence over again, and he is just basically saying, let them do whatever they want. And he basically said, as long as they're happy, he's happy. I think he's got to somehow rein them in and stop being just concerned about how happy they are.
Well, Brian, I know it's like reading tea leaves, but scheduling questions, wanting to see so many of the text messages, what's going on in that jury room right now?
Jesse, I think this is what we call a rogue jury. Rogue in the sense that they heard what the defense said, they heard what the prosecution said, and they say, you know what, let's put this to the side and let's figure this out for ourselves. And that's what I think they're doing. That's why they're going through each and every piece of these text messages and phone calls to try to make sense of who is more culpable than the other. I don't think the prosecution did a good enough job to kind of paint the picture of in for a penny, in for a pound, if you're part of this enterprise, so to speak, or these sets of crimes that led to someone's murder, you're all guilty. And I think the defense did a good enough job poking a few holes here and there, so they're kind of left to do it on their own.
Well, I said it in our last broadcast, I'm going to say it again, we will wait and see what happens. But there is new information that was released Tuesday that shines a new light on allegations of sexual misconduct against former Cowboys wide receiver Michael Irvin. The Hall of Famer held a news conference Tuesday to release surveillance video of the incident as he files a $100 million lawsuit against Marriott. This after Marriott made claims about the incident at its hotel. Irvin claims he was removed and his Super Bowl appearances were canceled. So here's what we know. We know that Irvin was staying at a Renaissance hotel in Arizona for the Super Bowl in February when he encountered a female employee near the hotel lobby bar. According to Marriott, Irvin made a lewd comment to the woman, making her very uncomfortable. In a statement, Marriott said that Irvin touched the woman's arm without her consent and continued to get closer as she tried to back away. Now, Irvin was able to get his hands on hotel security video after multiple court orders last week. And in the video, you can see Irvin and the woman having a conversation as he does briefly touch her arm But the entire thing seems to be pretty cordial, beginning and ending with them shaking hands. After learning new details about the incident, Irvin's legal team moved the lawsuit from federal court to state court in Arizona.
But when you get called in a room and you're said, somebody tells you, hey, pack your bags, you relieve your duty, go home. And I said, what happened? You sexual assault. So who when? But nobody was in my room. Well, don't worry about it. Go home. You know, I'm just thankful. I'm just so thankful for those witnesses. I'm so thankful for this video. Because without it, I just don't know where this would have gone.
And staying in the sports realm, good news for former NBA All-Star Shawn Kemp. Prosecutors in Washington state are not going to be filing charges against him after a shooting last week. On Wednesday, Tacoma police arrested Shawn Kemp, a former standout for the Seattle Supersonics, in a mall parking lot. They said that he had been involved in a drive-by shooting with another car. Now, Kemp's lawyer said that his car had been broken into the day before and items were stolen, including his phone. Now, he ended up tracking it to a car at the Tacoma Mall, but when he went to confront the people inside, they allegedly started shooting at him, so he shot back. The Pierce County Prosecutor's Office says that it won't file charges pending further investigation.